when you think about HIPAA, HIPAA is all about these transactions that take place in the background that you and I never see. These are all the things that have to do with the claims and eligibility and remittances and all this kind of stuff. That's the business of healthcare. All of that is what is really what the HIPAA rules are all about in their original format. Is looking at those transactions and making sure that you can change from one health plan to another and maintain your coverage. And that required having all kinds of ability to share transactions that understand certain information between insurance companies. So that's the Health Insurance Portability and Accountability Act. That's the portability part, is being able to change from one health plan to another. The accountability part is the Health Insurance Portability and Accountability Act. The accountability part is making sure that information is properly protected. They realized when they wrote the law that if you're going to be having all this information flying around for insurance purposes, you better make sure you have the proper protections in place to make sure it doesn't get misused or improperly accessed or abused in some way or other. So that's where privacy and security come from, is that accountability part for information. What the privacy rule is all about is establishing a framework of the relationship between individuals and the organizations that have their information. It's all about what are the rights that the individuals have for things like having access to their information or asking for copies of it or getting accounting of disclosures, all kinds of things. And the other side of the coin is for all those organizations that are holding on to that information and using it for healthcare purposes, how are they allowed to use that, and how are they allowed to disclose that to others, and under what circumstances? And when do you need to have extra things like authorizations or things like that? And just as a sideline, the whole notion here of access of health information, this is a big issue for HHS. Now there have been 2 entities that have been penalized recently in the HHS Right of Access Initiative. It's something that showed up as a big issue in past audit work, is a subject of numerous consumer complaints over the years, and has been a focal point for HHS to try and make this work better over several years now, and it's just not getting much better very fast. So they'll be pushing for some new rights. But one thing that's happened now with the whole access thing is some of the individual rights have been curtailed by a court decision. We'll let you know just exactly what has changed as we go along. That's just in the past couple of weeks. Anyway, so the privacy rule is all about the individuals' rights and also the controls on the organizations. Security rule is all the safeguards the organizations need to use to protect the information. Okay, it applies to electronic information, and the thing is, it's not overly specific. It's not overly detailed. It doesn't say your password management procedures have to include the fact that your password should expire after so many days. It should be so many characters and have this combination of characters. And no, it doesn't say all that. It says you have to have good password management policies and procedures, which is a good thing because they wrote these rules in a day many years ago when there were certain ideas as to what made a good password. Nowadays we have different ideas as to how to manage passwords and what they should be. And so it's all changing right now. And the security rule can accommodate that because it's not overly specific. Now, the other side of the coin there is that you have to do your homework to figure out what is the right thing to do for your organization. You have to do some risk analysis to understand your organization, identify where you may have some risks, and plan to mitigate those risks before something goes wrong. Okay, so that's a great thing. It's very flexible. It's very customizable. Which it really has to be because every organization is going to be different. How everybody does business is going to be different. I mean, a little tiny doctor's office that has, a doctor and a physician's assistant and a receptionist is not going to have the same kind of information security needs or complications that an academic medical center is going to have. It's a different scale of things, different quantities of things. Okay, so it has to be flexible, otherwise it wouldn't work. But if you use your risk analysis, you figure out what needs to be done for your organization and concentrate on that. And that way, you're going in the right direction. Now, the other rule that's on the horizon for HIPAA nowadays is the HIPAA breach notification rule that came along in 2010. If you have something that is a reportable breach, it has to be reported to the individuals who are affected and to the Department of Health and Human Services. Now, the thing is, you have to do all this reporting to individuals and HHS, even beyond the impact of whatever's involved with the breach. Just the reporting alone can be very, very expensive. Just if you have to send somebody a letter, you're talking about 50 cents for a stamp right there. So it can be very expensive when things go wrong. You want to be able to avoid breaches to the best of your ability, right? The nice thing is you can look and see what has happened to other organizations. HHS posts a listing of breaches that have happened and what organizations are involved. These are all for all the large breaches affecting 500 or more individuals. What are the organizations that are involved? What happened? What kind of situations were they? And so the thing is, it's a great learning tool to go out onto this portal that we all call the Wall of Shame. HHS doesn't call it that, but we do. And that's where you go and see, what's happened to everybody else, and you figure out, well, listen, these are things that happened to them. What can I do to avoid those problems that they had? Okay, because where you see somebody else taking a fall, that's the idea is you want to make sure you don't do the same thing. You're kind of foolish not to. So take advantage of the things that will show you what's going wrong for everybody else out there in breach notification. A couple of links on this slide here. Get to know what's in the rules. Okay, if you're going to be looking at patient access and data blocking, I always encourage people to get to know what's in the regulations. Don't just focus on the question you have today. A couple of things you can do. One is to read the 2013 Omnibus Update Rule Preamble. That's the big update that came along in 2013. In the preamble, they have lots of discussion of how to interpret the rules, how to answer certain questions. They entertain tons of questions and comments during the comment periods when they have these new rules, and they answer them all in the preamble. And so you can learn a ton about how certain things are handled. One of the questions that comes up in the preamble and has come up many places in the past is, what if a patient says, I want to communicate with you using a plain email? What if they send you a plain email message? Can you just respond to that? And the answer is, well, first you clear it with the patient so they know that there is a risk involved with using plain email, but if they don't mind that risk, if that's what they want to do, you can go ahead and do that if that's something that you can accommodate in your regular processes. And so they have a discussion of this and where this is justified within the regulations, so you can learn how they think about the rules and where they look up things, and you can use that same logic to apply to the situation of what if the patients want to do texting with you. Again, it has to be something that you can accommodate and deal with in your organization, but if that's what the patients want to do, you have to be able to accommodate at least their consideration of their request. So anyway, you can learn a lot when you read the preamble to the rules. The other link that's all the way at the bottom of this slide here is the combined rules as of March 2013. That basically takes all the amendments from the dawn of HIPAA time and puts them all together. There's a couple other minor changes that have come along since March 2013. One is people are allowed to have access to their laboratory records directly from the laboratories. That's one change. It has to do with access anyway. So just a couple of minor changes since the rules were published in 2013. Get to know what's in the regulations, okay? If you don't know what's in the rules, how are you going to be in compliance? All right, so get to know what's in there, and you look at it and go, my goodness, look at all this stuff here. Download a copy as a PDF, and you'll think this is pages and pages and pages of stuff, and where do you start? Well, I'll tell you where you start. You spend 10 minutes a week looking at it, okay? Your first week's assignment is just look at the table of contents. Look and see what's in the rules, where things are, what are the various sections called, what kind of things are we talking about here? How is it laid out, okay? Where do you think you might find certain topics and things like that, okay? So you can do that. You can do that kind of that kind of first kind of a scan to see, well, what do we have here in the table of contents? Your next week's assignment, I think, is a good one, is to discover all the sections in there, and there's a number of them. Usually at the beginning of whatever major section portions there are, there is a section of definitions. Find out what the words mean. Okay, so when you find out what the words mean, and you find out how things are laid out a little bit, you can actually start understanding what's in the rules. You can start to dive in and do some research and figure stuff out. So I encourage people to get familiar with the rules. Now, with that HIPAA, we also got the 21st Century Cures Act. When we talk about data blocking, that's where this comes from. Is the 21st Century Cures Act that came out a couple of years ago, basically, and it just takes forever to get rules put together these days. It's just it's not a big process. But anyway, information blocking, it's a practice where you have a provider, a health IT developer, or a health information exchange or a health information network that's likely to interfere with the exchange of electronic information. It's something that's likely to get in the way of a reasonable use of, access of, exchange of electronic health information, what they refer to as EHI in the 21st Century Cures Act. Of course, they can't use the same terms that we use under HIPAA. They talk about a more general term of electronic health information. So anyway, Section 404 in 21st Century Cures says that here's the things that might be information blocking. If there's things that are restricting authorized access, exchange, or use under state or federal law, that's the kind of thing that might be considered information blocking. So if there's something that keeps you from sharing information with somebody else, exchanging with somebody else, providing it to the individual if they want a copy, you have those kinds of practices in place, that's information blocking. Or if you implement health information technology in non-standard ways that would make it more burdensome to access, exchange, or use health information. So if you start using health information technology that makes it harder to share information, that might be considered to be information blocking. Or if you implement health information technology in ways that might restrict access, exchange, or use of electronic health information, or lead to fraud, waste, or abuse, or impede innovations and advancements in health information access. So there comes things. If you have various blockages of information, it becomes difficult to actually move forward with progress and improve technologies and improve healthcare through better technologies. That's the kind of thing that that's information blocking. It's getting in the way of progress, getting in the way of sharing information. It covers a lot of stuff, actually. It's really quite a broad net. Now, in Section 4006, they talk about empowering patients and improving patient access to their electronic health information. And this is interesting because this is where it overlaps with HIPAA. Okay, there's basically this is the kind of thing that HIPAA covers already. Is patients are already empowered to have access to their health information. Okay. And so what this does, it says the Secretary has to have various authorities to encourage partnerships between exchange networks and providers and health plans to make it easier for people to have access to their information in a single longitudinal format that's easy to understand, secure, can be updated automatically. I mean, basically what they're saying is you need to make sure that that we use whatever data we've got, whatever systems we've got, to try to create something that's easier for the patient to get a hold of all their information in and understand and use. Okay. And that means that what this means is HHS has to use whatever's at their disposal to eliminate improper data blocking. So HHS, is directed in the 21st Century Cures Act to use tools such as HIPAA to help achieve this objective. So there's a direct linkage between data blocking and HIPAA. And in fact, HHS has announced their right of access initiative and is making a point of enforcing the HIPAA access rules. There have been 2 enforcement actions just in the past few months, specifically having to do with the right of access initiative. So you want to make sure you're doing your best to start paying attention to what you should be doing when it comes to providing access. So for information blocking and HIPAA, information blocking, like I say, this is a hot topic at HHS. So we have some new rules on information blocking that have been proposed. They're being widely criticized. There's lots of controversy about this. In my opinion, it's time to stop information blocking. I think it's important for organizations to find ways to do what they can do to facilitate patient access of records, making sure you're providing it to the right people, making sure you're following the patient's intentions and things like that, and do what you can to facilitate transfer of records to other providers when requested by a patient. When a patient says, send my records over to this other doctor here who's taking care of me, you send whatever the patient is requesting you to send that's in your designated record set. If they're allowed to have access to it, and somebody wants to treat the patient, my feeling is it's time to make those kinds of transfers easier. Now, this is an area where the recent court decision has made it more difficult for individuals to make this happen under HIPAA. I suspect the the data blocking rules may address this as well, which will do away with that problem. But currently, the way the courts have decided is individuals have rights to ask for a copy of the records to be directed to themselves, but they don't necessarily have the right to have it sent to somebody else, which is absurd as far as I'm concerned. That's just one of the stupidest judgments I've heard in a long time. Well, in case you haven't noticed, I get opinionated about some things. But anyway, it's time for all of us in healthcare to do what we can to stop information blocking. Within your own facility, look and see what are you doing to make it difficult for people to have access to their records. Do you always make it as easy as you can to share information with other providers? I mean, I have cases where there are healthcare providers who want to get records on behalf of their patient to take care of the patient. And they finally get the records, and they wind up with these records where they both have the same kind of medical record systems, and they could easily transfer the information through a number of electronic mechanisms from one to the other to make it easy to have the records on hand. But no, the sending physician decided, no, we're going to fax it to them. That's childish. Okay, it's time for us to grow up. The patients need this information. The records belong to the patients. The copies of the records belong to the facilities, but the information belongs to the patients. And they have a right to get copies of it, and I believe that very strongly. It's time to stop kidding around with this. It's It's absurd that we've gotten this far in our world with healthcare in the U.S. that we're still dealing with this as a problem, that people can't get access to their information as easily as they should. So anyway, there have been two settlements recently for not providing timely access under HIPAA, and they're really looking at these as information blocking penalties by HHS. That's what they're looking at it as. So we're talking about under HIPAA, we're talking about PHI and usage disclosures and the designated record set. What are we talking about here? PHI is protected health information. Okay, under HIPAA, it's protected health information. It's individually identifiable information. It's about somebody's health or their health care or their payment for health care services, past, present, or future, in any form or format, whether it's sent by Aldous Lamp or carrier pigeon, put on a hard drive or carved into stone tablets. It's all PHI if it's individually identifiable stuff about somebody's health or their health care or their payment for health care services. Now, when the information is transferred to somebody else, that becomes a disclosure. These days, if you take care of a patient, you want to get paid, right? So you transfer some information to the health plan so you can get paid, either through a third party or directly to the health plan, depending on how you do your business. But basically, that's it. You're sharing the information with some other party outside your four walls. That's a disclosure. When you're taking advantage of that information within your organization, that's a use. Okay, so there's a distinction between uses and disclosures. They aren't the same thing, although some of the rules do refer to uses and disclosures together. When we look at a subset of all your PHI, okay, there's all kinds of protected health information. But when you look at all your protected health information, there's a subset of all your PHI that is just the stuff that's used to make decisions about the patient. Okay, what you do to decide how to take care of them or how they're going to pay for their services. That's referred to as the designated record set. That's the medical records or billing records generally that would be used to make decisions about the individuals. Now, this is what individuals have a right to ask for access to. And people have a right to know everything that was used and in whole or in part to make decisions about them. In other words, patients have a right to know, what were you thinking? On what information were you basing your decision that you came up with this particular diagnosis and treatment plan? I'd like to know where you got these ideas. What's in my records? What are you looking at that makes you think this? Okay? Patients have a right to know all that stuff you consider, even if you got it from somebody else. Patients have a right to get a copy of that. Okay? And here's where the issue is now, is that patients are allowed to ask for a copy of what's in the designated record set. They're allowed to ask for everything in there. There are some specific exceptions you can make, but patients are allowed to ask for a copy of that. And now the way the rules have been decided by the federal court is the patients may ask for that copy, but it needs to be directed directly to the patient. It can't be sent to somebody else. It has to go to the patient, or at least has to go to the patient first. I mean, this is only just going to make it more difficult for people to get access to their records and share them with the people that it should be shared with. This is more absurdity as far as the particular regulations are concerned here. I don't know how we're getting away with this. So we have the individual access process is basically that you have to have a process for the individual to ask for access to their information, and they're allowed to have access to their information for free. They're allowed to be able to look at the information at no cost. They're allowed to be able to have the information show up on a screen somewhere they can look at, and then they can take pictures of that if they want to, and you can't charge them for that. And you can lay out the records on the table for them to look at, but if they want to have copies made of those records, if they want you to make copies, you can make copies, and you can charge them only a reasonable cost-based fee for making those copies. You have to have a process for managing denials of access, so that you can, if you're going to say, well, no, you can't have access to certain information, it has to be for certain reasons, okay? And you have to have some way to handle that because some of the reasons for denials of access are subject to review by the individuals if they so desire. So you're supposed to provide the entire record in the designated record set if that's what they're requesting, which is basically the medical and billing records used in whole or in part, as I was saying before, to make decisions related to health care. There are some important exceptions. There is exceptions for psychotherapy notes, and those are just the notes that a therapist is taking during a particular psychotherapy session. Once those notes get turned into something in the medical record, like progress notes or treatment notes, something like that, that becomes part of the medical record. But before that happens, those raw notes, those are the psychotherapy notes. So a patient doesn't right to have access to that. Also, information you may have compiled for various legal proceedings, those kinds of things. The patients still have a right to have access to the underlying information, but the bundles you've created for your own legal purposes, they don't necessarily have access to that. There's also a great number of exceptions under the category of if harm may result, whether it's to the individual or to somebody else, or if it might reveal a source of information that was given in confidence. In many cases, so there's all kinds of exceptions for providing the information. But that's the important thing is if you're not going to provide what people are asking for, you have to be able to understand what the exception is and why you can say no. Information that's kept electronically, people have a right to have an electronic copy of, so long as it's some kind of a reasonable format that can be produced. Lab results can be accessed by the individual. That was effective of April of 2014. And there used to be an offsite data extension for providing access that gave you an automatic 30-day extension for offsite data. Well, nowadays offsite data is more likely in a data center somewhere, not in a dusty box in a warehouse. And like I say, access is a hot button issue for HHS. And like I say, as well, the recent federal court decision says third-party access requests on behalf of the individual are not to be considered the same way as individual access requests and not under the same access rules. The whole thing is individual access requests are subject to certain limitations in fees and certain scope of information that's available that third parties would like to be able to take advantage of, obviously. But basically they have to go through the individuals to get that information now. They can't get it directly. So is it important to manage the access of records properly? Yeah, it's one of only two situations in the privacy rule where you must release PHI. One is if HHS is asking you for PHI related to a compliance enforcement activity, then you give them whatever they're asking for. But the other is when the when the individual wants to have access to their own information. That's when it gets released under the privacy rule. That's a required release of the information. It's a required disclosure. And also, based on enforcement actions, there have been a number of enforcement actions going way back to one that there was one enforcement action that involved a $4.3 million fine for a group that didn't provide access as requested by individuals. And then furthermore, when the investigators had questions from HHS, they didn't respond to those investigators. So that happened a number of years ago. That's a basic example there is if HHS has questions for you, don't ignore them. If individuals are asking for copies of their records, don't ignore them, okay? There'll be a couple of enforcement actions in late 2019, though, for individual access complaints. Yes, based on enforcement actions, yes, it was a focus of the 2016 and 2017 HIPAA audits. And also based on the 2012 HIPAA audits, the top two privacy issues were basically access related. And actually, if you look at three of the top five were access related, but it's right off the top of the bat. You see, the review process for denials of access was basically out of compliance, and also there was basically some issues with failure to provide the appropriate individual access to records. So yes, and yes. By the way, this is a key issue under macro and meaningful use. If you're getting money, the incentive funding for your EHR system, you have to make sure you're doing things like providing individual access the way you're supposed to according to regulations. So you really can't get away from it. So as far as what's in the actual regulations themselves. We have in 164.524, that's where all the right of access stuff is in the privacy rule. In 164.524A, the standard in place is you have to be able to, the individual has a right to access, inspect, and get a copy of the PHI that they have in the designated record set. Again, that's just that stuff used to make decisions about the patient, okay? Except for psychotherapy notes and except for information that's been compiled for legal proceedings. And that's also where they used to have an except for laboratory information. But now that exemption has been removed, so that's now out of the regulations. So if you're familiar with the old rule, that's been changed. That's where the CLIA exemption used to be, but now that's out. So anyway, has a right to access, inspect, and copy DRS information, except for psychotherapy notes and stuff that may be collected for legal purposes. And there's all kinds of unreviewable grounds for denial and reviewable grounds for denial. Okay. So there's you can deny review of the grounds for denial. It's unreviewable if it's exempted under the section we just looked at. Okay. Also, if there's inmate records that might jeopardize the health or safety of the inmates or others, or if there's research going on. Okay, and if the patient says, "Oh, I want to be able to have access to my information about the research that's going on," well, if the research is in progress and the notice that was signed about the research says, "Sorry, you don't have access to your information until the project is over," because otherwise it might damage the results of the project. Okay, well then they can deny access so long as that's what the notice said. So that's another unreviewable grounds for denial. That's the kind of thing where sorry, you can't contest that. Or if it's subject to the Federal Privacy Act, or if it comes from somebody other than a healthcare provider under a promise of confidentiality, and the access request would be reasonably likely to reveal the source of the information. Reviewable grounds for denial include things like where it might endanger the health or safety of the individual or others. Okay, so if it looks like it's going to be dangerous to the individual, it might say, "Listen, we can't let them see this information. This is too dangerous for the individual to see this." Okay, or if the person sees this information, they may get really angry and want to threaten somebody else. And it could be, if the information references another person who's not a provider, and access could cause substantial harm to that person. See, that's the kind of thing you have to worry about. Or if the access is requested by a personal representative who may cause harm. If you have suspicions that one of the parents may be abusive to a child, and the parent is acting as a personal representative, wants to look at the records to see what's in the records, it could be that the parent looking at the records may wind up causing some harm to the child following the revealing of the information. So it's you want to make sure you look and see, well, who wants to have access to the information. And what is happening to the information? We don't want to wind up having it be the kind of thing where it could be causing some harm to someone. And also, so if it is a reviewable grounds for denial, if it's one of these Section 3 items here, health or safety of the individual or personal representative might harm, one of those harm things. If it's denied under number 3, the individual can request review by another licensed healthcare professional to see if that decision is a reasonable one or not. It doesn't need to be somebody from a different organization. It just needs to be a different licensed healthcare professional who will look at that request and say, should that be a reasonable denial or not, and should the patient have access to that information. So as far as the access process is concerned, in 164.524b, when it comes to requests for access and timely action, you have to permit requests for access, and you may require those requests to be in writing. But if you do that, you have to have in your notice of privacy practices something that says that yes, you will have to submit your request for access in writing. But otherwise, you need to be able to, however it is, permit requests for access of PHI in the designated record set. And you have to act within 30 days. Let people know what your decision is, whether you're going to provide the information or not. And if you can't act within 30 days, you can get a 30-day extension, but you have to ask for it. I mean, you have to basically tell the patient, sorry, we need more time. Here's why. You don't get any automatic 30-day extensions. You have to actually, inform the patient that you are behind schedule and let them know when you are going to get around to doing it. So it makes so the patient is aware when they have an expectation of when they might get their records. As far as providing the records go, if you're giving them access, you have to give them the access that they need to have. If there are duplicates of the information, you only have to show one copy. You don't need to show duplicates of the same information to the same individual necessarily. And when it comes to access and individual preferences, there's a couple aspects to this. They can see the lower half here looking at 164.524c. That's more of the Section 524 stuff about individual access. But here's where it ties in with confidential communication requirements under 164.522. We look at individual preferences for communications, okay? Covered healthcare provider has to permit individuals to request and must accommodate reasonable requests to receive communications of PHI by alternative means or at alternative locations. So this is the kind of thing where, you can tell your doctor's office, listen, please send mail to this P.O. box. Don't send it to my home address. Call me on my cell phone. Don't call me on my home phone. Okay, so that's an allowed communications kind of a situation you have there where you're allowed to ask for these kinds of things. And HHS looks at this and says, well, you can also apply this to a situation where somebody wants to use plain email instead of a secure website. I mean, for instance, I'm one of these crazy old guys who does not like the idea of having to use a secure website. I have to learn so many IDs and passwords. I'm so sick of them. It's crazy. It's gone beyond what's reasonable. I really don't want to. I mean, there are a lot of people like me who say these kinds of things, right? I want to be able to use plain email to talk to my doctor's office. And what this says here is that you have to accommodate reasonable requests. And when you look at the provision of access in 524C, you have to provide the individual with access to the PHI in the form or format requested by the individual if it is readily producible in such form or format. And if not, in some other kind of form that would be agreed to and usable, the kind of things that would be agreed to by the covered entity and the individual. So you can provide the individual with the access in the form or format requested by the individual if you reasonably can do that, okay? So this all comes down to, if somebody wants to communicate with you using plain email, can you handle that, okay? First thing is the patient has to accept the risks. The second thing is you have to adopt that as a real communications process, that you have the ability to handle incoming messages and be able to have documentation of any kind of activity that takes place, okay? So there's allowances for using plain email under the privacy rule. Individuals have certain rights to communicate in the way that they wish to, regardless of what the security is. And if you do your risk analysis under the security rule, you'll say, well, you can't use plain email; it's not secure. Yeah, that's true. You can't use plain email for business communications, for professional communications. But when it comes to the individuals, they're allowed to ask that. Because you have to start from a standpoint of, me. I'm one of these people. I don't care. I would rather have the easy access to my information and use plain email. But I don't really care about any of the medical information that's passing around about me right now. And if I were somebody else who had a very sensitive position in the world, there may be some conditions that I wouldn't want to know, wouldn't want the world to know about. And so I might feel some of these things are way more private, and I might have different opinions about how to communicate. So you have to come, have to kind of start from a careful standpoint when it comes to your communications, and assume people want to be private, and then have them request doing something that may be less secure. So the idea is you have to evaluate the risk and present this to the individuals. You look and see, well, what are we talking about here? What might happen if the information gets out, and what's the likelihood that's actually going to happen? And it really depends on the details of what kind of email is used, what the circumstances are, how well that the information is protected at the receiving end, and things like that. But if you talk in terms of, how bad might it be if the information gets out, and how likely is that to happen, then the individuals can consider that and make a decision based on real knowledge about what they should or shouldn't be doing. As far as 164.524C is concerned for providing access, more on that is you can also, if the individual would prefer, you can provide the individual with a summary of the information they're looking for. And in many cases, that's the kind of thing that can be a whole lot more useful. I mean, for certain medical records, I would think that a summary might be way more helpful and useful than just looking at the raw information. And if there's going to be any fees involved for preparing a summary, the patient has a right to agree to those and make a decision as to whether or not those that such a summary will do for them. Now, as far as the time and manner of access, there's been some changes here according to the recent court decision. Covered entity has to provide the access in a timely manner, okay, but it's also in the regulations here. It says the individual may designate a recipient of the information, and this is what's been struck down by a recent federal court decision. They make it so it's not necessarily okay for individuals to direct their information to go to some other recipient using the same fees and process that they have for individual access, okay? Because there's certain limitations on the fees for individual access. If it's me coming to ask about my records, they're only allowed to charge me a certain amount, okay? Just labor supplies, postage, whatever cost to prepare a summary, just those actual costs of preparing the copies. You can't include capital or equipment costs, and it has to be, based on what those real costs are, or it could be there's a state level that could be even lower than the HIPAA level is, okay? But basically, whichever is less expensive for the patient is the one that's supposed to count for the patient. But what's changed now is the individuals can't, under those same fees, say, yeah, here, I want a copy of my records and then send them to someplace else. See, here's what happened, is the rule got abused, okay? What happened is basically the lawyers discovered that, if you want to get copies of records, have it filed as an individual access request. You can get a full copy of all the records at the lowest possible cost. And so the problem was that the companies that were in the business of managing the release of medical records were losing their shirts on this, because stuff they used to make good money on in the past by providing copies to lawyers and insurance companies and things like that. Now this is the kind of thing where when they want to get this kind of stuff, they were just asking for it under the individual rates, and it really wasn't really being used by the individuals, but it was being used on the individual's behalf. So, I can see why there was a problem with it, and why it was the kind of thing where it was causing some anguish for some parties in healthcare. But at the same time, it seems nuts that the individual can't say yes and send it to me, or send it to my brother-in-law, or send it to my lawyer, or wherever. Okay, and it doesn't need to be this limiting. I think it's an absurd limitation. I think it better be corrected quickly. It makes me very cranky, as you might tell. Anyway, so now when it comes to denying access to information, it has to be for the right reasons. Okay, if you're going to be denying access, if you deny some access to some information, you have to allow access to the other information. Okay, if you're denying access, it has to be timely. Okay, you can't wait till the end of your time limit. If you're going to deny the access, do so in a timely fashion, in plain language, including what your basis is for the denial, whether they have rights of review, if those would be applicable for that basis of the denial, and also how to complain to the entity in HHS. Okay, so if they're not happy with the answer, they need to know how to complain to you, and how to complain to Health and Human Services. Now, if the covered entity doesn't have the information but knows where it is, they have a responsibility to inform the individual. That's an important thing. If a patient comes to you asking for certain information, and you go, "Oh no, we don't have that." Okay, the patient is, "I got to have a copy of this information. I need to have this information." And they say, "Well, we don't have that." Well, then, if you know where it is, you have an obligation to tell the patient where it is. Okay, there's no playing dumb here, right? And if the individual does request a review of a denial, then you have to designate somebody to do that review and actually do the review and make a decision. And also when you talk about regulations, you have to talk about documentation. So you have to make sure you have everything in this documented according to 164.530J, which is kind of the master documentation section for HIPAA. What you have to have documented is what is a designated record set that individuals have a right to have access to, and who is the person who's responsible for receiving and processing requests. Now, it's kind of interesting. There's a line between covered entity and business associate responsibilities. And when you think about it, we have all these rules for how to handle providing access and things like that. And lots of rules for how all kinds of things happen. And a lot of these things that get done these days are managed by business associates on behalf of the covered entities. Okay, so when that's the case, when a covered entity hires a business associate to do certain things, and it comes to certain aspects of providing access to records, where do you draw the line for the responsibilities, okay? What they've said is that there's basically some the business associates are responsible for carrying out the terms of their business associate agreement, first of all, but there's some limitations on liability for compliance and provision of access. So basically what happens is the business associates, if they're involved with providing access, they're liable for provision of access regarding the form and format and time and manner of access. Okay, so when the patient says, "I'd like to have it in this kind of a electronic format, or in paper or fax or whatever," so as far as providing the form and format and the time and manner of access, and in terms of when you'll have access and how you will do that. Okay, so the business associate is responsible for that actual, providing of the information. Okay, but when it comes to, is there a problem with how much you're being charged for this, you're supposed to take that up with the covered entity, not the business associate. Okay, the covered entity is responsible for the liability of compliance with the reasonable cost-based fee limitations. Okay, so what that means is the business associates are off the hook, and the covered entities are the ones that are liable for those kind of fees, those kind of limitations. So if you feel like you're being charged too much for an individual access request, your complaint goes to the covered entity, and they're the ones who will be in trouble if you may wind up making a complaint to Health and Human Services. Basically, if you have any problem with getting copies of your records, if somebody won't provide copies of the designated record set to a patient, there are places on the Health and Human Services website where you can go to basically to file a complaint with Health and Human Services and say, hey, I want to have access to my records, and they're not letting me have it. They're taking too long. They're charging too much. Whatever. That basically there's a process to file a complaint, and HHS is quite used to following up on these complaints, and are quite prepared to go after all kinds of circumstances where somebody's information may have been denied to them when it should have been provided to them. So there's this new line that's been drawn for the liability when it comes to providing access, and you can take a look at the guidance on liability that came out in May of 2019. There's also some guidance that has come out for communications and access guidance. Now, keep in mind, these first 4 bullet points, these are all examples of guidance that include the question of using plain email. Okay, and there's also the bottom bullet point has to do with guidance on access, especially having to do with minors and mental health information. But what we're talking about here is, when you're looking through this guidance on access, the top bullet point here, the 2016 guidance on access, that's a guidance document that's had some of its content struck down. In other words, when you're looking there and they talk about requirements to share information with other parties based on an individual's request, that's all of what's been struck down. So you have to read through that carefully since some of that guidance is now invalidated. It's great when we're moving in a good direction, getting out good guidance, and then suddenly the federal court says, oh, no, actually, you can't look at that. Oh, really? Okay, fine, thanks. So, we're looking at this guidance on the guidance on access regarding mental health in minors. There's a few, kinds of things they talk about in there about the fact that, does HIPAA allow a healthcare provider to communicate with a patient's family, friends, or others who were involved with the patient's care? Yes. Okay, even if it's mental health, HIPAA makes no distinction between regular health information and mental health information. The only kind of information that's different under HIPAA is the psychotherapy notes. Okay, so when it comes to mental health information, you're allowed to share information with family and friends and others who were involved in the patient's care in a normal way, the way you normally would under HIPAA. Okay, and same, the healthcare providers are allowed to do that kind of thing. And since there's no difference on mental health information as far as other information is concerned, then that's the kind of thing where the healthcare providers can talk about these things with the patient's family. Now, there may be some other limitations under 42 CFR Part 2 for substance use disorders, but as far as HIPAA is concerned, that won't get in the way of having these kinds of reasonable conversations to help take care of the patient. Okay, is a healthcare provider permitted to discuss an adult patient's mental health information with the patient's parents or other family members? Yes, unless the patient objects. Again, mental health information is the same as any other. You have to give the patient a chance to be able to object to the disclosure. And when you look at a minor child's doctor, can the minor child's doctor talk to the child's parent about the patient's mental health status and needs? HIPAA wouldn't get in the way, but there could be some issues with state law when it comes to you're dealing with children and minors. You always have to be careful. There's quite often some special limitations that there can be about the information about children about particular things such as mental health and particular health conditions. Now, so it's also about the guidance regarding mental health in minors. A few more questions they have is, does HIPAA permit a doctor to contact a patient's family or law enforcement if the doctor believes the patient might hurt themselves or somebody else? Yes. That's a health and safety exception that we have. If somebody is going to be hurt by following the regulations, you don't follow the regulations. You make sure somebody doesn't get hurt. You're in healthcare, right? So, if you think the patient's going to hurt themselves or somebody else, and you think you need to notify the family or law enforcement to help prevent that, you're allowed to make that call. Okay, it's the kind of thing you'll certainly want to document. Is there a duty to make that kind of a call based on ethical standards? Yes, maybe state law. HIPAA doesn't necessarily have a duty involved with that. Does HIPAA deal with the school administrators, school doctors, and nurses in how they share information with the students' parents or law enforcement? Well, when you're talking about a school administrator or a school doctor or nurse, if it's information that's collected at school, it's under FERPA. It's not under HIPAA. FERPA preempts HIPAA. So when there's students' information at the school, even if it's health information, it's protected according to FERPA, not HIPAA. And if a law enforcement officer brings a patient to the hospital be placed on a psychiatric hold and wants to be notified when the patient is released, can the facility do that? Well, you have to have some kind of a written statement of need. Certainly if there's in cases of a threat to health or safety, if they believe that the individual could be a threat to the community in some way, it's reasonable to say, please let us know when you're going to let them out. Okay, so there has to be some reasonable reasons why that's the case, and usually helps to have some kind of written statement of need to handle this sort of thing. So when you're talking about substance use disorders, okay, we're talking about the world of 42 CFR Part 2. And for those organizations that provide referrals and treatment for substance use disorders, those entities that are subject to 42 CFR Part 2, you have to make sure they follow the various limitations on disclosures under Part 2 rules. So if you're a Part 2 entity, that means that you provide or refer substance use disorder services, and you receive some kind of federal assistance, such as something as simple as a DEA license, or you have a tax-exempt status. Those are considered to be federal assistance. So it's very easy to wind up as a Part 2 entity if you're providing or referring for substance use disorder services. But the idea is the 42 CFR Part 2 is to protect individuals who are seeking help with their substance use disorders. Okay, and what the story is with Part 2 is every disclosure requires a consent. Now, HIPAA allows all kinds of disclosures for treatment, payment, and healthcare operations. All kinds of use disclosures for treatment, payment, and healthcare operations, without any particular consent. Okay. But Part 2 does require a consent for every disclosure. So a lot of stuff that HIPAA would allow easily and automatically, you can't do unless you have a written consent under Part 2. And there's plenty of issues, obviously, where you have a facility that provides a Part 2 program within a larger facility. How do you identify those records that are Part 2 records, and what counts as Part 2 records, and how do you know what's Part 2 records? And maybe you have a Part 2 patient, while they're being treated for their Part 2 situation, it's discovered they have measles. Well, the measles information is not Part 2 information, but the substance use disorder information is. How do you keep all this separated, right? All these mixed records and processes, it gets very difficult. You know, we've always had a disconnect between HIPAA and 42 CFR Part 2. It's been that way ever since the dawn of HIPAA. But it hasn't been a problem until now, because now we have so many electronic exchanges of information, all those kinds of situations where we have various records that are, working together or shouldn't be working together, or should be accessed or shouldn't be accessed. The modern world and all its electronic information has now forced this clash between Part 2 and HIPAA. And the big thing under Part 2 is that there are strict limitations on releases to law enforcement. The whole thing is you can't use Part 2 data to go after somebody for a drug violation. It's their treatment information, and it can't be used for those purposes. So how are you allowed to communicate with patients, okay? So what you want to be able to do is do what the patient wants, first of all, okay? You have to be able to meet the HIPAA requirements, accommodate whatever you reasonably can, meet the patient's needs for different purposes, everything from prescription refills all the way through looking at test results and accessing your medical records or having conversations with your doctor. And the idea is when you're talking about communications with your patients, the thing you have to think of is, how can we do this properly? Okay, there's, yes, meeting the patient's needs and answering their questions and things like that, but what are we doing here? You're providing patient care. You have to have a process that makes it possible for you to be able to receive messages if you choose a path of communication. So you have to be able to receive these messages and process them properly. Send them off to the right people to be answered properly and make sure they are answered properly, and make sure these things are properly documented. Okay, so no matter whether you're talking on the telephone or sending letters back and forth or faxing or having in-person conversations, it all has to be handled properly for patient care purposes. It has to be processed properly and recorded properly in documentation. That's really what we're talking about when we talk about handling the communications properly, is making sure that you can process them properly and document them properly. So what are the HIPAA considerations? Now, when you look at the security rule in 164.3.12, it requires you to consider the encryption of communications. It's an addressable implementation specification. That means you have to look and say, should we do this or not, okay? And when you look at using things like texting and email and things like that, you realize, well, these things are not secure. When you do the actual examination, these things could be very easily, the information could be harvested or stolen or whatever. They're not designed to be secure in the first place. So you have to consider the encryption. And when it comes to communications for professional purposes, then you need to make sure those communications are properly secured. But the privacy rule gives patients certain rights to communicate how they see fit. One of those sections we looked at in 522 and 524, where they have rights to communicate in the manner that they wish, in the form or format, et cetera. So they have certain preferences for access of information that they're allowed to exert. And so the idea is, to the best of your ability, make the patients happy, because happy patients tend not to complain to Health and Human Services, right? So long as you can provide the access the patients are looking for, and so something that you can manage as far as a communication process is concerned, do it, okay? Make the patients happy. Make it easier for them to get what they want, and makes it much less likely they'll complain to Health and Human Services about you. Now, when it comes to professional communications, you want to make sure that you do secure these things. When you do the risk analysis, you can see you can have a problem. If you use something insecure, you may have to report it as a breach. You have to do some evaluation, see what actually happened. It's not always obvious. It's a very difficult question to answer in a very short fashion. I get the question all the time, well, such and such, blah, 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 is that a reportable breach? I said, well, I haven't heard anywhere near enough to be able to tell whether that's reportable or not. I need to hear all kinds of background information and analysis of what actually happened, all kinds of things. So we have, if you're using insecure communications, that might be a breach. There's been enforcement actions against organizations using insecure communications for professional purposes. And in fact, CMS has advised their state survey agency directors way back in the end of December of 2017, that's a couple of years ago now, right? They said, listen, texting of PHI within a care team is permitted only if it's secured. So you can do some texting within the patient care team, but it's got to be a secured process, not just the plain stuff that comes with your phone. And texting of physician orders is prohibited whether or not it's secured. They don't want physician orders to be involved with texting in any way, whether those text messages were secured or not. So that's an important little bit of guidance there to help us understand how HHS feels about this topic. So the idea is you have to establish a process to handle requests and to handle people's individual preferences for communication. You have to be able to accommodate reasonable requests, to be able to mail to alternate addresses or not receive telephone calls or whatever. If the request is unreasonable, you can refuse it, but you have to be able to at least consider the request that you might get. There's all kinds of processes individuals may want to use, such as email or texting or social media, all these various things. The idea is you need to use some risk analysis to determine well, what's going to be suitable here in these circumstances, and then get consent to be able to do that. So you have to understand what might be reasonable or not, discuss it with the patient so they understand what the risks are, and then get their consent to be able to go ahead and do that. So you have to make sure you have some documentation of how you handle your communications with your patients, and anticipate the fact that you're going to get some requests to do something else. As soon as you think you got one thing handled, they're going to say, well, listen, can we communicate using Facebook? And there you slap your hand on your forehead and say, oh, my goodness, no, please, can we just not even discuss this? Please don't request that officially. Because, there's just, people have no understanding of the risks of their privacy these days. But the idea is you have to have some flexibility in mind, okay? When you're talking about communicating with your patients, encourage them to use your portal. You should have a secure portal or some way for them to easily, securely access their information. Okay. If they're looking for copies of their information, make sure they can get access to what they need through the portal. Don't forget there could be information that's in the designated record set that could be outside of what's accessible to the portal. So make sure you understand what the portal is providing in case somebody wants something that may go beyond that. Make sure you provide a variety of means of communication. Make sure you're prepared to deal with a variety of means of communication that you understand and you manage. And you have to provide and encourage using secure solutions for communications. You have to encourage people to use some kind of a secure process, okay? But you've got to be ready to do something other than what your preferences are, okay? And so you have to have policies and processes for considering those requests to do something that maybe you're not doing, and make some reasonable decisions and how you're going to document those decisions and go forward. Now we talk about email, texting, and security. Email and text are inherently insecure by themselves. So we talk about, patient access to information. Again, the whole issue here is that the consideration of encryption is something you have to look at, okay? Because email and text are inherently insecure. When you do your risk analysis, you'll see it probably needs to be encrypted over the internet. And the plain mail, plain Gmail, Yahoo Mail, plain old email, texting, consumer grade stuff. This is all insecure stuff. Unless there are special precautions taken to secure the communications, which you don't necessarily have guarantees of most of the time, you have no guarantees the information is secured. What that means is that if you wind up with somebody using something like a plain email application and sending a PHI, and the question comes up, well, is that a breach or not? You have to do some evaluation, you have to do some research and find out what was the situation for the communication of that message, and was it sent securely or not? Because sometimes you don't know. And sometimes it can go securely, other times it won't if there's certain bottlenecks and things like that. But we do have technologies for securing communications. It's just that some of them aren't easy to use, and patients like me hate to use difficult-to-use websites and things like that. But the guidance does say plain email with patients is fine. The idea is to evaluate the risks and discuss them with the individual. The Health and Human Services Officer Civil Rights Head says that texting at the patient's request is okay, just like email. So when you look at, is it okay to communicate using email with the patients? Yeah, if they want to do that, if they understand what the problems are. And it's the same thing for texting. So what can go wrong with email and texting? It's great for, scheduling and renewals and things like that. Email is great for communications, but again, it's difficult to secure. Email was never designed to be secure in the first place. It's basically to be something on the order of texting, but meant for the internet, way back when, and it grew into way more than that. And texting is great. It's a fast way to communicate short messages, but it can be more discreet and private than a phone conversation. It can be more accurate than the phone. But in either case, these communications are not secured by default, and they can be retained or exposed by unknown parties. And so you don't really have any assurances of privacy or security in the chain of communications unless you explicitly establish a secure process to be able to do this. Now, when it comes to texting, there's some issues with texting. First of all, people aren't necessarily going to appreciate the risks of loss of privacy through texting. HIPAA says you have to do what you can to meet patient preferences and try and explain the risks, but we may not understand how bad it is to use texting to the extent we do for 10 or 20 years, and we start realizing that people have been saving our text conversations, and we'll be able to recreate our entire histories, and probably erroneously through our text messages. Anyway, so there's a whole bunch of privacy issues with texting that are really unknown so far. Texting doesn't give you a good paper trail for medical records. You have to have good documentation if it's medical, part of patient care, right? You can still use texting for administrative purposes, so long as there's no PHI, okay? But once PHI gets involved, you want to make sure you have things properly documented. And when it comes to patient safety, you want to make sure that you're able to triage the incoming messages, because regular texting doesn't automatically go to different individuals, okay? You have to have a process set up to be able to manage all this. And make sure you provide the appropriate service. Also, make sure you keep in mind if you're talking about communicating with people and providing them access to their information, if they want to communicate via their cell phone, if they want stuff to be sent to their cell phone, TCPA, the Telephone Consumer Protection Act of 1991, limits calls and messages to cell phones without having a consent in place. Basically limits robocalling, including reminder calls, unfortunately. And if you don't have a consent in place, you can wind up with the penalties just for leaving a payment message, voice or text. And also, there's penalties for calling a cell phone and leaving a healthcare-related message in more than 1 minute or 160 characters, no more than 1 per day or 3 per week. So that means even for healthcare purposes, if you're going to be leaving more than just a few messages a week, you need to have a consent from the individual. When people give you a phone number these days, what is it? It's a cell phone number, right? So you want to make sure that you get their consent to use that number to reach out to them for healthcare and financial purposes, including reminders and follow-up. And so, keep in mind, if you get a signature acknowledging receipt of the Notice of Privacy Practices, and that Notice of Privacy Practices says the patient may be contacted using their contact information, that counts as a consent for healthcare operations, according to a court decision. It doesn't count for payment operations, but for healthcare operations, that counts as a consent if the individual did sign the acknowledgement of receipt of Notice of Privacy Practices. So there are some secure solutions for texting, which is nice. I mean, there are some things, some ways to approach the problem. If for within your office, you ought to be using a secure texting product anyway. These top ones here, this first bunch, these are all free. They have some simple free versions that just establish a secure point-to-point communication process between any two parties that have the same technology installed. And so you can have everybody in your office have Signal or Telegram, and have them all communicate with each other using a secure process instead of the insecure process. And so even if they don't use any PHI, it's secured. So if they accidentally do, it's secured. Okay, and definitely if you want to use PHI on a regular basis, if you don't need to have it documented or whatever, you can use one of these free ones. If you want to get fancier, you can move up to a paid version. It'll handle documentation and reporting and things like that. There's also things like Cortex, TigerText, and DocHalo, these kinds of things that can be integrated with your EHR system. There's also integrated communication solutions, the kind of thing where you can work with the patients to understand how they might want to be communicated for various purposes, depending on how secure things are or what the information might be. And some patients may say, no, send me a secure attachment to my email. Some patients may say, send me an insecure email. Some patients may say, send me a message that says I have a secure message waiting for me on the server. I mean, there's all kinds of ways that you can handle these kinds of communications to meet the patient's preferences. And these secure texting things like PingMD and OMD are really good at enabling that kind of thing. When it comes to using insecure communications with the patients, you want to make sure you have a policy about that. Reminding people that for professional purposes, it needs to be secured. Otherwise, you want to make sure you define how you would be normally doing your communications and what the preferred insecure alternatives would be. You want to consider what you're reasonably able to do. And HHS's opinion, I think, is that you should be able to handle plain email if that's what the patient wants to do. So you want to be able to, it needs to be an expressed preference by the client or the patient, whatever your terminology is. It needs to be their expressed preference to be using some kind of an insecure process. It needs to be, you can ask them, would you prefer to? Then it becomes their preference, okay? It can't be, don't you want to? It would be so much easier for us. That's the wrong approach. But if you want to say, wouldn't you like to? It would be so much nicer for you. And then they, oh, yes, my preference is this. They indicate their preference, and you can do that, okay? But, they need to indicate some preference as part of this process. If they want to do something other than what you're normally doing, you can consider it according to the sections of the rules we're looking at in 522 and 524 and the guidance that's out there. And if you want to do something that's insecure, make sure you explain what the risks are, get the patient's consent with a signature if that's what's appropriate. That's normally how you would document those kinds of things. And then get the word out in your organization to people who are going to communicate with this party as to how to do that. If you don't go through a process of making sure you know how to handle how to get the word out within your organization, it doesn't do any good to agree to communicate with the patient in a certain way if you can't make that happen within your organization. So document the request and your consent or denial with the request. And so, of course, big question is, can we text appointment reminders? Okay, so when it comes to sharing information like appointment reminders, you need to meet the HIPAA and TCPA regulations. Under TCPA, you have to have consent for healthcare communications to a cell phone, either by signed consent or acknowledgement of receipt of the Notice of Privacy Practices. And on the HIPAA side, you need to make sure that you look at the security of texting by using a secure texting app if you can, or using only minimal information in reminders, such as the date and time only, preferably from a third-party reminder service. In other words, just send a message that says, don't forget your appointment tomorrow at 1:30. Not your appointment tomorrow, Tuesday, whatever, at 1:30, your appointment with Dr. So-and-so to deal with your such-and-such condition. No, just don't forget your appointment tomorrow at 1:30. Use the minimal information, or have the individual express a preference for using an insecure process, okay? So if the individual says, I don't want to have to download another texting app. Can't you just send me a text message in my regular texting app? That's what I'm used to using. Okay, so you can have that kind of be the kind of thing that an individual can express as a preference. So when it comes to the guidance that came out in 2016, when it comes to individual rights and requests for access, individuals have a right to a broad array of PHI. Individual's personal representative also has the same right to access the PHI about an individual in a designated record set. Now, in this case, an individual's personal representative is not just somebody who is asking for the patient's records as a third party. It's somebody who has the authority to act on the patient's behalf for health care decisions. It's like a parent of a child is what we're talking about here, okay? So the parent of the child has the same rights for the child's information that the child would have, okay? So they have the same right to access. But the information is provided to the individuals and not to third parties now. That's a big change now is that information is not supposed to go to the third parties. It's just supposed to go to the individuals. You may require that any request for information be written, but you can also offer an electronic method. You have to identify whoever is asking for the information and use whatever judgment you're used to using in those circumstances. And you can't do anything unreasonable. You can't require that the requests have to be in person only, or by web only, or by mail only. I mean, look, I live in Vermont. If I went to California to do some work and I broke my leg while I was out there, and I got back to Vermont and I wanted to get a copy of my records, it wouldn't make sense to have me have to go back to California to get those records now, would it? So you have to be reasonable in whatever you're asking for your processes, how that's done. You have to provide it in the form or format requested if it's readily producible, including electronic forms or email or whatever. It has to be done in a timely fashion. Fees need to be cost-based only. HHS's opinion is you ought to be providing free copies wherever you can, and that there may be no charge to view records. For people to just look at the records, there's supposed to be no charge for that, for the individuals to come and look at their records. And if you're going to deny access, you have to have a process for that and the ability to handle requests for reviews of denials. We've talked about where that comes from. Okay. Also in the guidance, they talk about the fees. They say it's only just the labor for copying, not for reviewing or fetching. And the supplies and postage. The fees are set by the actual or average costs for a type of request. Okay. They also talk about using some flat fees for electronic copies of records, but they went on with some further guidance beyond that to discuss the fact that it needs to be something that's based in reality on what the actual costs are for the making of the copies. They also feel that per-page fees for electronic copies are not appropriate. They also insist that you may not charge for individuals to review their information or to access the portal that has their information. So you can't charge people just to come in and look at their information on your portal. And whichever costs less, whether it's state law or HIPAA, if you have competing regulations as to what the cost can be for medical records, whichever is a better deal for the consumer prevails. And the other thing is, see, if you don't use the individual access requests that people want to use, they have to get the information under an authorization. Okay, those third parties would ask for an authorization instead of an individual access request. And with the authorization, other fees are permitted. Okay, you don't have those fee limitations in providing information under an authorization. That's just for an individual access request. So it's taking the pressure off the organizations that provide information to be able to push people back into the authorization camp instead of just using individual access requests. When you're looking at what it's supposed to do, it sounds like it's the kind of thing it sounds like it's a reasonable thing to do according to the court's point of view. Whether I like it or not, I don't like it, but I think it's probably reasonable according to the court's point of view. So what do we have? There's also some questions and answers they have in the guidance. You cannot withhold access for non-payment of fees. If patients haven't paid their bills yet, they still have a right to see their information. Okay? If they want to have a copy of the information, you need to charge them for that copy. You can withhold that copy until they pay for that copy. Okay? But you cannot withhold access for non-payment of fees. I mean, think about it. Sometimes patients need a copy of the records because they have a beef with you, because they don't want to pay the bill. Okay? Because they think there's something wrong with the bill. And so, if they haven't paid the bill yet, you can't say, oh, no, you can't have the records. No, they need to have access for that, okay? You cannot charge people for looking at the records and making their own photo of the records. Here's where the individual can designate a recipient of his copy under the same fees. That's now been struck by the federal decision. And it needs to be transmitted securely unless the individual requests something insecure, like plain email, okay? Access does not require authorization. They are not the same thing. Don't get confused. Access and authorization are not the same process. You don't need the same kind of information. For an access request, it's very simple. Who are you? What information do you want out of the designated record set? Okay. Whereas authorizations have all kinds of disclaimers and lists and exceptions and all kinds of. I mean, it's a whole huge document. Whereas an individual access request is very simple. The access and authorization are completely separate sections of the regulations. Don't get them confused. Don't use the same forms one for the other. HHS will get cranky about that. There's plenty of other categories of questions and answers about what information is covered by the access right and timeliness, form and format and manner of access. It's important to note that the entity itself is not liable if the individual requests insecure communications and a breach results. Okay, so the individual says, "No, I want to do it this way." You say, "Are you sure? It could be, it could be breached. There could be a problem with privacy or security." And the individual says, "No, I want to do it anyway." Okay. Well, if there's a breach that happens, After that, then the entity is not liable. Okay, and also the entity is allowed to consider its own security in deciding how it's going to accept or deny various methods of providing access. And there's plenty of other questions and topics as well. So what happens when things go wrong? What happens when things go wrong is you may have a breach situation. Okay, breach is where you have any acquisition, access, use, or disclosure in violation of the privacy rule. That's a big definition. Okay, and when something goes wrong, there's a violation of the privacy rule. It involves an acquisition, access, use, or disclosure of information. That could be a reportable breach. Okay, there's some exceptions. For unintentional internal uses with no further use or inadvertent internal use, like you look up the wrong record by mistake. You're supposed to be looking up the record, you just happen to pick the wrong one. Okay, that's the kind of thing that's not necessarily a reportable breach. Or if you lose something like a box of records and you get it back and it still hasn't been opened, it's still sealed. Okay, if the information cannot be retained by somebody, that's not a breach either. All right. Now, if you don't have those exceptions, but you still have that privacy rule violation, the next question is, well, is it something that possibly could have been encrypted? Okay, and if it could be encrypted, the idea is, if it is a breach and it doesn't qualify for one of the exceptions, the idea is you want to be able to encrypt that information, and then you don't have to report it. Or if it gets destroyed in the process, you also don't have to report it. But the idea is, if you have the ability with electronic information, the more you can encrypt this stuff, the more chances you have to avoid having it breached. Right, so encrypting your information using good quality encryption is a good idea. It helps you avoid breaches. Okay, now so if you have the acquisition, access, use, or disclosure in violation of the privacy rule, you have the exceptions that you may or may not have, and maybe you have the information is properly secured, or maybe it's not. If you get to the bottom of the slide here, you get to the point where you have to look and see what's the probability of compromise based on a risk assessment, looking at what is the information, how sensitive is it, how identified, where did it go, was it looked at, was it mitigated. You have to do an examination of the entire incident and see if there's been a compromise. And, of course, the word compromise is a very vague term, not defined by HHS, but it means that something has gone wrong. You've lost control of the information. You don't know that it's been safe. If you don't know it's been safe, it's been compromised. Here's a little table that will step you through the breach analysis. If you wind up in those circumstances, you need to think, okay, do we have a privacy rule violation? Yes or no? Do we have an internal exception? Yes or no? Do we have some way the information might not be retained? Yes or no? Was it secured? Yes or no? Do we have a low probability of compromise? Yes or no? And basically the idea is you can decide every step along the way whether you need to go any farther or not, but if you decide that you don't need to go any farther, you better have some documentation as to why you think that's the case. You have to be able to justify your reasoning as to how you decide something is not reportable. So whenever you evaluate any of these kinds of things, make sure you have plenty of documentation on hand to be able to explain and show what's the whole process that you went through and how you decided something wasn't a reportable breach. So when it comes to breach analysis and plain email and texting, if we're talking about patient access, right? A compromise is a loss of control or a violation of security policy that may result in exposure, corruption, or loss of information. So what information are we talking about? How clearly identified is it? Is it really health information, very plainly so? And what's the context? Sometimes the context of the information can provide more information than the information itself once you put it together. And what do we know about where plain emails and text messages go and who looks at them? There's so many unknowns involved in the process. There's so many things that we don't know. And mitigation through disclaimers can help, okay? And the idea is you have that little disclaimer at the bottom of your messages, at your email messages, that says, if you got this inappropriately, please delete it and don't give it to anybody else. That's a mitigation action to say, please don't spread it any farther. It doesn't undo what's already been read, but it helps perhaps keep somebody from sending it on who shouldn't send it on. As far as trends and breaches, yes, hacking and ransomware impact are way up. Laptops and portable electronic devices are still the leading easily preventable cause of breaches. These kinds of things, you can lock these things down better these days and easier these days than you ever could. So make sure you don't have portable devices wandering around with PHI on them. We have malicious or innocuous insiders, either one, people who are working for you. Either they're evil or they make mistakes. They're a huge problem. We have increasing new threats from new technologies like insecure email and texting and social media. And we still have breaches that just affect one or two individuals, but they still happen a lot. All these paper handling mistakes. I still hear about these things happening all the time. So breaches are caused by hackers, loss of information, theft of information, malicious insiders, user errors. But basically what happens is if you have in place good security processes that will help protect your information, protect access to your information, protect your networks, you have good security methods. People are trained to know how to do things the way they should to be acting in a secure fashion. And you have good people, okay, who are good at heart and they've been properly trained how to do the right thing carefully. Okay, that's how you avoid breaches. Okay, there's all kinds of good guys and bad guys out there, but if you have good people working for you who are properly trained and they're backed up by good processes and good security methods, they can help you avoid problems. Your staff is your front lines in security. They're not the weak link in security. They're the front lines. I mean, let's think about this. You think about World War I. You got these guys out there working in the trenches, and they're doing their best to try and move the front lines one direction or the other by a few feet if they possibly can. All right. Well, they're out there. What do we say? Oh, they're our weak link because they're out there, being bombed and all kinds of poison gas and shot at and all kinds of stuff. Is that our weak link? No, that's our front lines. That's the way our users are these days. They're the ones that are being bombed and gassed and things like that. They're in the front lines of dealing with the outside world on their computers. So you need to make sure you have people properly supported to do the right things. So what about HIPAA audits? We talked about what happened in the 2012 audits. It's kind of interesting when you look at the 2012 audits. You can see the privacy issues. Look on the right-hand side down there. You can see the 3 of the top 5 issues have to do with providing access to patient records. So that's why this is a big issue with Health and Human Services, is whenever they do audits or when they look through their list of complaints that people have, they see this problem as a huge problem, and it has to be dealt with, okay? So people have to make sure that they have a good review process for denials in place and they provide the appropriate access when they should. And when somebody comes as a personal representative, they have to treat them just the same way. So it's important to, we've learned some things from the HIPAA audits in the past. The process is not continuing now for the future. They aren't considering to move ahead with any more audits for the time being. They've canceled it for the moment. But if they bring it back again, it's a great way to find out what you need to worry about. I mean, that's what these audits are for, is to look through, not to punish entities, but to find out where we can improve compliance. And so it's clear that, according to the audits, that basically the access is a key area. It needs to be improved. It always helps to look through what kind of questions have been asked in the past. And when you're looking at providing patient access, you can always look through the various questions having to do with patient access in some of these questionnaires as well. Probably the one that's most useful these days is the 2018 HIPAA audit protocol, where you can look through and see, well, what are the questions HHS would ask if they were doing an audit for compliance with the access provisions. Okay, so it's important to know what HHS might ask you. Well, here's one thing you can do is go through this audit protocol and answer all the questions to the best of your ability, and then improve your compliance where you see any weaknesses. It puts you in a good shape. Okay, and the audit protocol, when you put it into a spreadsheet like this, you can say, well, here's different kinds of questions that we have, and what it's about, what categories, and here's the questions that they're asking, and then you have some space on your spreadsheet to put in, well, what's my answer to these questions, and what documentation do I have to support my answers, and what outstanding issues do I still have that maybe I want to come back and address, and maybe I'll give them a priority, and then sort out the spreadsheet by priority. Always make sure you add an item number all the way on the left-hand side. They don't have any item numbers in the web page, and some of the contents of the cells refers to item numbers, so it's really helpful to give them all an item number. So what's in the audit protocol for when it comes to denial of access, for instance? They ask, do you have policies and procedures to make sure somebody gets a timely written denial that contains all the mandated elements? Does it have all the bits and pieces that need to be there? Okay, so review policies and procedures to make sure they comply with the established performance criterion, which is basically looking at the rules. Do you have the stuff that's supposed to be in there according to the rules? And they also say, well, listen, show us a sample of your denied access request. So you better make sure you have this kind of documentation ready to go and make sure it would pass muster as performing the kind of service that it was supposed to be able to do. I mean, when you're looking at denied access requests, you should be able to see a process that, something that shows that you have a process of people requesting access and it being considered and it being denied. So that's what you have to have documentation to be able to show that. Okay. Looking farther along in the audit protocol, look at item 69 and looking at reviews of denial of access. They say, do you have the policies and procedures in place to deal with reviews of denial of access? Okay, so look at the policies and procedures, see what there is. Do we have the right process? Do we have the right way to follow through on things. It basically takes you through a whole bunch of questions to examine if you have what you need to be in compliance with the regulations. And this, and they also say, oh, by the way, review the documentation that you got under item 66 to make sure you've really covered the bases. Okay, and so again, these are all questions that there's lots of little bits and pieces. But if you go through and answer these questions on any particular area in the regulations, it can help you understand where you may want to put some more effort to feel good about your answers. Because that's the whole thing, is you need to feel good about your answers. You need to feel like you can defend them. And then even if you're wrong, you have some place to stand because you have thought about it, right? I mean, there's nothing worse than not having thought about it. You're so much better off if you think about how to be in compliance and work on being in compliance and do your best and have explanations as to why you're making your decisions, okay? So even if you do something wrong, you can show, here's how I got there. I thought I was being reasonable. And HHS says, well, geez, thanks so much for thinking about it. It's really helpful for you to think about it rather than just ignoring it like so many. So we have some new regulations. There's basically these things linked to the HIPAA rights for individual access, but they also call for interoperability and easy access for providers, because currently providers are considered to be a third party on the outside, according to this court decision. So the idea is to make it easier for people to share information so they can take care of the patients. And there's plenty of controversy, there's people signing petitions and taking sides as to what should or shouldn't be and what should or shouldn't happen. And I'm basically of the opinion that all this silly whining has to stop. We have to get to the business of making sure people have easy access to their information and have the ability to share information as they see fit. And let's do this right, shall we? So there's plenty of controversy, plenty of potential privacy issues or security issues involved with sharing and providing access and removing blockages to information. So audit your own compliance on access. Okay, ensure your policies and your notice of privacy practices actually meet with what's in the rules. Make sure you handle any denials properly. Make sure your fees aren't too high under HIPAA or state maximums. Make sure your practices are working properly so you can determine whether you're actually in compliance or not. Make sure you have consent for using insecure communications. Make sure you verify your documentation. Review any exceptions to what you normally would do. If you do something outside of the norm, it should be written down. Take a look at that. Make sure it's something that you really should be doing. Verify that you are using also secure communications for all professional to professional communications. There's just no getting around that these days. Now, if things go wrong, you may have to deal with a penalty. The penalties have all gone up recently, except there's some annual maximums for the lower tiers have been reduced to reflect the culpability in those violations. But all the base numbers have been increased by a cost of living adjustment. So the maximum that used to be $1.5 million is now $1.7+ million. And of course, they can multiply any maximum by the number of violations that take place. And any particular thing that goes wrong under HIPAA may involve multiple violations. That's all there is to it. So be familiar with what can go wrong. Don't go down the pathway of willful neglect. That conscious, intentional failure or reckless indifference to the obligation to comply, don't even think of that. That's the wrong approach. It won't work for you well these days. There has been enforcement action on data blocking. There was going all the way back to 2011, there was a fine for a doctors group that denied access to at least 41 people who complained, probably others who didn't complain. And they got hit with a $4.3 million fine, including $3 million because they were just ignoring the investigators. That was willful neglect there. But there was basically in September 9, there was the $85,000 settlement with Bayfront Health St. Petersburg for not providing a mother timely access to the PHI of her unborn child. And so this is basically, they look at this is a HIPAA and data blocking issue. It's the first enforcement action in their right of access initiative. And as the OCR director says, it's important to make sure that people have the access that they're supposed to have. And let's stop being foolish about this. And there was also most recently in December of 2019, another $85,000 settlement with Corunda Medical of Florida for not providing access in a timely fashion, for not providing the information in the format requested, for charging more than a reasonable cost-based fee. HHS even provided them assistance on how to do it right, but didn't do that. Okay, so they got mighty cranky with that and said, okay, penalty time for you too as well. So make sure you're providing access the way you should. Don't dawdle. Don't postpone this. Do it the way you're supposed to. Now, as I mentioned before, the business associate liability for HIPAA compliance, according to the May guidance, is Business associates are only liable for the various things, but they are liable for cooperation with the Secretary of Health and Human Services, not taking retaliatory action, failure to comply with the security rule. It's a big one, right? The business associates have lots of obligations, but when you get down to what we're talking about today is the number 6 here, okay? And what the business associates are responsible for is the obligations, if they're working for a covered entity, is to provide the records according to the form and format and time and manner of access rules. But when it comes to the fees are what the covered entity's obligations to make sure are being handled properly. So anyway, all the business associate liability does provide a line of where to draw the responsibilities. If the covered entity hires a business associate to provide medical records, they have to do it right as far as time and manner and form and format. But the cost for the records, that's the obligation of the covered entity to define what that cost is going to be, and they're responsible for that being appropriate. You also want to make sure your staff is properly trained to respond to requests for access. People need to know how to give the right answers. If somebody asks them a question, it's a topic that is of current interest, I think you want to make sure you provide some training for your staff and some reminders as you go along. Make sure you're doing your best to share information as your patients would see fit. And if you want to put in secure solutions, that's great, but they will require some dedicated effort. So you want to make sure you have the support from your management at the top, and get plenty of training and reminders and verification in place so that people will know how to handle patient access in a secure way. And document all your HIPAA activities to create your HIPAA compliance activity history. All your policies and procedures, every action, activity, or assessment, and keep it for 6 years from when it was last done or last in effect. So your to-do list is, don't be in denial because willful neglect is expensive, okay? Review the new guidance on access, accommodate individual rights, review and update your policies and procedures, make sure you have processes for risk analysis and documentation. Look at your access and communication policies and procedures and update them as necessary. Update your notice of privacy practices if you need to. Make sure it all matches. Make sure your staff is properly trained, your policies and procedures, and have plenty of documentation on how you're supposed to do things and everything that you have done. Do some drills in audit and breach response. Practice having something go wrong, so when it does go wrong, you'll make better decisions. And then make corrections based on the results of your drills in audit and breach response. Always have a plan for moving forward. Always have some idea in mind of what you're going to do to improve things, and follow that plan going forward.